Thanks.
Mr. Brian Mabea, Mr. Edward Oonge, Ms. Jane Odia.
Come again.
Inform you.
Good morning.
I'm appearing with my colleague, Ms. Nana. For the respondent.
I wish of the respondent in the original application. As we speak, this court is not aware of the true identity of that respondent. Secondly, the respondent to shed light why the full identity of the subject of the search was not disclosed to the court. So after shedding light on the two issues, the court will give appropriate directions. Proceed with the first, which is Ms. Likieyo. At the time of making the application.
Yes, Your Honor.
That is sufficient.
Kind permission. Thank you.
If you knew all the names by the time of making the application, I know that is where you wanted to lead to. Why did you suppress other names?
Ms. Nanga, for the EACC. Your Honor, the applicant is an investigative agency. Mandated to conduct investigations. And as to the why, Your Honor, the applicant has an obligation to ensure that they secure the integrity.
Too fast. Remember I'm recording.
Very well, Your Honor.
So the applicant
Has an obligation to ensure that they secure the integrity of the investigations that they are undertaking.
clarify the integrity, you want to secure.
The integrity in the sense that, Your Honor, that the nature in which such warrants are conducted is required to be discreet, to avoid interference with investigations.
You want to say a judicial officer, the one seated here, is classified as one who can interfere with investigations.
Your Honor, that is not the case.
Clarify that further. About 20 minutes to give further directions on the matter. So the court will adjourn for 20 minutes.
The defense team will meet outside there. You can't right there, run and say you are.
Kenya Appeal Reports at page 168. Until this morning, evidence of the true identity of the subject of the search order was not available to this court until it was confirmed by counsel representing the applicant in the original application. Today, having confirmed the true identity of the respondent in the original application, upon inquiry by this court, and for reasons apparent hereinafter, I find it instructive at this point to state that I will not here and determine the main prayer of this application and all other applications connected to this matter. Picture this: the applicant in the second application plus her husband have been and remain not only close personal friends spanning a period of approximately 17 years, dating back to 2008, but also family friends with close ties with my nuclear family. Regulation 47 of the Judicial Service Code of Conduct and Ethics, regulations number 102 of 2020, provides as follows. I will quote the necessary parts only. 1E, the opening paragraph is: a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might, underline might, reasonably be questioned whether the judicial officer, I will skip to E, is in a relationship with a person who has a personal interest in the outcome of the matter. And G is precluded from hearing the matter on account of another sufficient reason. The context presented in the original application, where the full identity of the subject of the search order was undisclosed fully to the judicial officer, to the fullest extent, best exemplifies both the enduring wisdom and the indispensable significance of the requirement of full and frank disclosure of material facts, and in this case, the true identity of the subject of the search order. Had the respondent to the present application made a full and frank disclosure of the true identity of the subject of the search order, then pursuant to the said Regulation 47(1)(e) and G, I would not have determined the application in the first place. Instead, I would have recused myself instantly and directed that the file be placed before the head of station for possible reallocation. Although it is a practice I found entrenched in this court, apparently founded on the morbid fear for sabotage, henceforth, this court will not entertain, underline entertain, similar applications if the full identity of the subject of the search order is undisclosed. The morbid fear of sabotage should not override the rule of law, and more particularly, the obligation fastened upon an applicant to make a full and frank disclosure of the material facts. Besides, although it may be used as an internal administrative measure to avert sabotage, it should not be extended to the court of law in exercise of its judicial authority, which exercise is required to benefit from the full and frank disclosure of material facts in order to render decisions from a fully informed standpoint. Full disclosure of material facts goes beyond disclosure of the full identity of the subject of the search, but also covers other contours which may materially determine the trajectory an application ought to take when placed before any judicial officer. For instance, invoking the doctrine of absurdities, what if there is no full disclosure of material facts and it ultimately turns out that I recuse myself from this matter? This court directs that the file be placed before the head of station for appropriate directions. In this connection, there will be a mention before Court 1 on 17th March 2025 at 9 a.m. Finally, granted the issues raised in Milimani MCAC, miscellaneous application number E377 of 2025, and Milimani MCAC, miscellaneous application number E378 of 2025 are similar, it has always been a sound judicial practice that such matters are heard and determined by the same judicial officer to avoid the risk of running into judicial embarrassment, where two judicial opinions can possibly emerge from two separate courts on similar issues, competing for the attention and prevalence of the readers. Consequently, the file in Milimani MCAC, miscellaneous application number E378 of 2025, will work hand in hand with this file, and they will both therefore be placed before the head of station for appropriate directions. Those are the orders.
By this court, we shall be seeking that they.
Ms. That is Ms. request by Mr. Mari for extension of the interim relief of the stay of the search order dated 12 March 2025 and its consequential actions is granted to last until 17 March 2025.
Motion.
The women gender. Ms. Martina can...
Good afternoon, ladies and gentlemen of the press. I will highlight briefly that we were before Honorable Ondieki from the Anti-Corruption Court, who has just recused himself from dealing with the ex parte application, where the respondent's full disclosure was, there was material non-disclosure of the identity of the respondent. And it so happens that the respondent, Honorable Stella Atambo, who is a chief magistrate and a very respectable member of the judiciary, the EACC obtained ex parte search warrants in a bid to search her premise and search the business where she conducts her business and even her residential home, without fully disclosing to the Honorable Court who the respondent is. And the first issue when we met in the courtroom today was the EACC was tasked to disclose who the respondent actually is. And the reason why the Honorable Magistrate has excluded himself from these proceedings is because of conflict of interest. Now, we are moving in a way that the EACC is trying to get orders without material non-disclosure, and these orders are ex parte, which means the respondent is then denied the right to be heard at that juncture. And this is becoming infringing on constitutional rights such as dignity, because then again on Monday or Tuesday or any other working day, we are supposed to appear before the Honorable Magistrate. I have appeared before her as and when I was a student and even as an advocate, and I really commend that to be one of the best judicial officers and a role model even to us women, and therefore these unfair attacks that are unfounded cannot be held, cannot be sustained. Therefore, we are asking the EACC, even in their discharge of their mandate, they need to constrain themselves within the provisions of the Constitution. Otherwise, we will be in a country that is not regulated by any laws, and yet we have very clear and unambiguous laws. And also, we are noting with concern that they got these ex parte orders without the involvement of the Director of Public Prosecution, who we all know under Article 157 is the one bestowed with the powers of all matters prosecution. And this, we are hoping in the fullness of time, will come to light. As we stand today, the orders for the search warrant and any consequential action thereof has been stayed by the Honorable Court, and we hope that even as we appear before any other court of competent jurisdiction, that the court will consider both sides and balance the wheels of justice while upholding the dignity of this judicial officer, while upholding the integrity of what is known as our Constitution. I rest.
2 million shillings. The advocate for the owner of the 2 million shillings, Shadrach Wamboi, can address over that issue.
Thank you, members of the fourth estate. My name is Wamboi, Shadrach Wamboi. I represent Mr. Evans Achoki, the husband and the head of family of the Honorable Stella Bunereri Atambo. Now, my client has instructed me to call out the improper practice, the sharp practice that we have seen being practiced by the officers of the Ethics and Anti-Corruption Commission. Now, it's an improper practice, largely because they have thought or they have designed a mechanism of secretly, surreptitiously dealing with matters in a manner that does not disclose the true identities of the persons they wish to investigate or search their premises. Now, for this reason, we have seen a situation where the Ethics and Anti-Corruption Commission has, in other words, brought some discord or has now strained, or in an attempt to strain the relationship between the person of the Honorable Ondieki, who is a family friend of Mr. Achoki, and the family of Mr. Achoki. Now, to that extent, you see a situation where the investigating agencies, as opposed to helping us in cementing the relationships that we have in this country, is at the center of creating a situation where it is turning a friend against a friend in the name of investigating. So to that extent, my client finds it very uncomfortable. More to that is that the investigating officers, knowing too well that the money that they recovered from Mr. Achoki's house, the 2,070,000 shillings, belongs to my client, Mr. Achoki, which was recorded in an inventory, went ahead last evening to make a publication in a manner to suggest that this money is a proceed of crime flowing from some certain bribes that were received by the Honorable Stella Atambo. This is very unfortunate. It is very unfortunate because they knew too well from the inventory that they recorded at the house of Mr. Achoki that this money does not belong to the Honorable Stella Atambo. But yet again went ahead to make a publication that is meant to soil the name and of course to create a certain narrative in the public that this money is a proceed of crime. Now, let me just say this for the public record, because we are lawyers and we have a duty to inform the members of the public about what the law says. It is not illegal to keep money in the house. You are not mandated by law to store your money with Equity and these other banks that are there. You can keep your money in your house, and there is nothing offensive about it. This Republic of Kenya is not a Maseno school, where teachers took fault with students having more than 200 shillings in their custody. This is the Republic of Kenya, and you are at liberty to keep whatever money you have with you. I mean, in any event, 2 million shillings. 2 million shillings is not an amount of money that should be so outrageous, that should, bring a lot of discord with the members of the public, or surprise us that you are having 2 million shillings in the house. Only. I mean, 2 million shillings is just pocket change. This is money that was meant to be used. This is money that was transactional. So you cannot criminalize. You cannot criminalize someone having kept 2 million shillings in their house. So, to say the very least, this is very unfortunate coming from the members of the EACC to criminalize the actions of my client opting, other than keeping the money in the bank, the decision by my client to having kept these monies in their own house. So moving forward, I am hoping that if at all the EACC thinks it is criminal to have more than 1,000 shillings in your house, they should go and liaise with the members of parliament so that they can legislate over that issue. But as far as my client is concerned, it is not wrong for them to have kept that money. We have applied before this court for those monies to be released to my client. I mean, it is so wrong that even as we are enduring these economic times, that the EACC believes that so all of us must be poor. All of us must be poor. You should not be having money. So that when you have money, it is now a subject of discussion in the public. So next week, as we shall be appearing before the head of station of the ethics of the anti-corruption court at the Milimani Law Courts, I shall be persuading the court to release this money. This is money that should be utilized to ameliorating the lives of my client, to ameliorating the lives of my client's family. This is money that should be utilized so that my client can pay school fees and meet the needs of the family as the head of that family. So without saying much, I will pave the floor to my senior, Mr. Danstan Omari, for further directing. But at the very least, the EACC should behave. It is not wrong to keep money. It is not wrong to have money. And if people are poor, if people are struggling, you should not brand people who have money as criminals. Thank you.
In the same vein, before you pen off, all of our rubbish.
yes, you can see the kind of dishonesty that the EACC is conducting its practice. I mean, they have created an illegitimate way of practice so that they can achieve what they think is a legitimate, objective that they have as an office. So while the president is everywhere promising and sometimes even carrying bigs or hefty bags of money in the term of 20 million and the likes, and they have not arrested him or criminalized whatever he's doing, why is it that they are now looking at a person, a Kenyan, who has been working for you should be having the manner in which we want to practice law in this country? An Anti-Corruption Act to achieve some ulterior motives that we are now seeing being peddled at.
Appears for Honorable Atambo.
A judicial, in the affidavit, they are saying the money is unexplained. Yet somebody is telling you, this is my money. What other explanation do you need? But you want now, because of public relations and you being irrelevant nowadays, what do? You go and say, oh, money was found in relation to the investigation. Why are you damaging somebody's reputation who has worked so hard by mere allegations? That officer by the name Mulinge must know one thing. This cannot be the end. You cannot tarnish somebody's name and think that you'll get away with it. At the end of the day, because this matter will end, and we know it shall end positively for the Honorable Magistrate, you will have to explain. You will have to answer for it. Somebody tells you, this is my money, I am going to do some transactions, and is able to explain, and that man tells you, this is my money. What is wrong with him having that money in the house? He has told you, this is my money. You have no warrant against him. You have no investigation orders against him. You still take his money. And you now want to remove his shine and oil yourself and stand in glory that you have done something. You have done nothing. What you have done is illegal. It is malicious. You still have to pay for it. If the people we expect and trust will do a good job and we shall always have confidence in them can do such a thing, I think that EACC should be disbanded, everybody given a piece of it, and they all go home. Because I tend to think the incompetence is not starting only from the top, it is also starting from the bottom. You have officers who have come from there, who have sworn affidavits, and all they say is, you look at it, there was no disclosure. It was intentional. Why? Even if you want to believe that you want to do some of these things in secrecy, at least disclose to that person. Come, even if it's an ex parte, after that serve. All these things affect the well-being of persons. It's her career, the career of the person, the husband, the children who are there. Mental torture. There is anguish. There is suffering. Mr. Mulinge, think twice. We are coming for you.
Mr. Nyaberi, we did a big presser yesterday, but I want to reiterate the following. One, Mr. Atambo right now is sitting at Thika Law Courts, presiding over her matters. So anybody alluding that she was escorted and detained at the EACC is wrong, factually wrong. Number two, we have full instructions. We have full instructions to sue the commission called EACC for the purpose of disbandment on the grounds that, one, they occasioned a forgery before the court of law. 2, we shall be writing a complaint to the Director of Criminal Investigation to investigate one, Nicholas Muringe, and the others for uttering false documents and giving false information to a public officer being a magistrate. This matter must be investigated thoroughly. Free, the defamation that has been put in the face of the learned magistrate, we shall be dealing with it in a manner appropriate and known by law. 4th, we shall be taking head-on the DPP for abdicating his job as the one authorized by law to prosecute. This application was sneaked in by people masquerading as state councils in the office of the DPP. Article 147 only mandates the DPP. 157, only the DPP can bring a matter criminal to a court of law. So those officers, those people who purported to sign that miscellaneous application pretending to be officers who have been delegated power by the Director of Public Prosecution, we are coming for you. This practice must come to an end. Kenyans are governed by the Constitution and the laws applicable. What we are seeing is EACC turning itself into an illegal entity that is above the law, that will do what they want, the way, the manner it is. Yesterday, our client was detained at a police station at EACC. She was illegally arrested, illegally detained. We shall be moving to get compensation for malicious detention of our client without any lawful authority from the court. Kwa hivyo vile nilisema, tuna instructions za kufuata wale ambao hawakufuata sheria, na tutamuuliza Director of Public Prosecution ajaribu atueleze kesi ya Jumatatu itaendelea vipi. How will the matter proceed to the exclusion of the Director of Public Prosecution? Thank you very much.